Welcome to Transnational Competition Law course. And dear learner and viewer, I am going to discuss with you the comparative law perspective on embarrassment of extraterritorial application of competition law in developed and developing countries. You can recall my previous lecture on the same theme, wherein we have discussed in detail as to what exactly we are going to dissect by saying that the comparative law perspective, as we have taken note of the embarrassment of extraterritorial application of competition law in developed and developing countries in my previous lecture, and we have devoted enough on the issue of the embarrassment of extraterritoriality and its gradual process of incorporation among developed and developing countries, along with the international law development by United Nations Conference on Trade and Environment, Organization for Economic Cooperation and Development, and International Competition Network. We have taken note of the slew of law which has been handed down by these three major institutions and how they have refurbished the entire corpus of extraterritorial application of competition law. With this, we then move that what are the different kind of the approaches which we have in the competition law, and in the approaches to competition law we have been very apt in discussing the different approaches which are to be found in the developed, developing, and underdeveloped world. And we reach to the point that all the extraterritorial provisions of Argentina, Brazil, China, Egypt, India, South Africa, Russian Federation, Vietnam, Ukraine, and Turkey. Taken together, it represents probably all parts of the continent of the world. Along with, we have taken note of Germany's Bundeskartellment Enforcement Mechanism, Korean Competition Authority, as well as the United Kingdom's Competition and Market Authority vis-a-vis the South African Competition Act and France Autorite de la Concurrence and the entire system of European Union in developing a very cohesive approach but containing all kinds of diversity in relation to the embarrassment of the extraterritorial application of competition law. Then we have been dwelling extensively as to what happens to be the national law on competition, what happens to be the regional law, what happens to be the international law on competition. And among all these three laws which have been handed down and which have very meticulously tried to embellish the entire corpus of the international competition law, especially the extraterritorial application of competition law, under the three broad headings. The one is the enforcement, another is the embarrassment, and the third is providing the competition remedies, a range of competition remedies by amicably resolving all kinds of competition dispute. Having learnt that, dear learner, we noted that what are the broad nature and trends of the comparative law in relation to the competition law, because despite that we have the niceties and the sophistication of the national competition law, and we have the other set of the regional competition law, and we have the international competition law, the soft international competition law, or the competition law which has been developed on the basis of committee and cooperation. in giving an impetus to the extraterritorial application of competition law, the need for comparative law perspective cannot be exaggerated and cannot be underlined, cannot be overemphasized in the sense that the comparative jurisprudence of the competition law, especially in the extraterritorial application, because the trends of universalism and trends of particularism in competition law synthesizes some very salubrious and some very pleasant propositions of and very finest reform and exposition of the extraterritorial application of competition law. To this end, we have discussed in detail that what are those major trends and nature of extraterritorial application of comparative law in the arena of embarrassment, enforcement, and the remedial action of extraterritorial application of competition law. We have, dear learner, taken note of uh, United Nations Conference on Trade and Development Model Law 2010, and we have very carefully perused the entire corpus of that law, whether that be the substantive part or that happens to be the commentaries part, and we have taken note that how the model law of United Nations Conference on Trade and Development in 2004 to 2010 happens to provide a kind of a model on cross-border merger and indirect effect of the forum and underlying activities of anti-competitiveness, and these commentaries and the lawgiver which has handed down the United Nations Conference Model Law on the Competition 2000, the glossaries and commentaries taken together has been a very rich kind of the repository in matters of extraterritorial application of competition law. Then we refer to the old principles of United Nations Conference on Trade and Development, especially the set of multilaterally agreed equitable principles of 1980, and we have taken note of the fact that how by the element of prior informed consent and consensus at the multilateral level, the developed countries and developing countries happens to promote an equitable principles of the extraterritorial application of competition law. Then, dear learner, will be moving to the another dimension, that what happens to be the nature and trend of the comparative law and what happens to be the grand norm of the competition law, or what happens to be the model law by the United Nations Conference on Trade and Development 2010, and besides that, what happens to be the real import and connotation of United Nations Conference on Trade and Development, multilaterally agreed equitable principles of 1980. Dear learner, we will try to see that what emerging dimensions and horizon it has developed in case of embarrassment, enforcement, and remedial action of extraterritorial application of the competition law. To this end, what we find that there is a global acceptance of the model law of United Nations Conference on Trade and Development, and there is also a universal acceptance of United Nations Conference on Trade and Development 1980 law, which talks about the multilaterally agreed equitable principles on competition law. But we see that these two laws generally gravitate around the basic doctrine of the United States antitrust law, that is the effect doctrine, and these laws have given a very widest possible amplitude of the effect doctrine in matters of competition law. Therefore, the scope of the national law of competition to international business activities are more important in the context of the section 18 of the United Nations Conference on Trade and Development Model Law on Competition 2010, which envisages that any competition agreement used to enter into various bilateral and multilateral agreement is based on the principle to prevent the market from inequity and ensure a free and fair market and reasonable trade practices. So the section 18 happens to carry a salutary impact under the comparative jurisprudence of the competition law. There are various other countries along with United States and European Union and India. They have accordingly adjusted and have rehabilitated their competition law to suit the ideals of United Nations Conference on Trade and Development, Model Law on Competition 2010, and as well as to suit the requirement of the United Nations Conference on Trade and Development sets of multilaterally agreed equitable principles of 1980. In that sense, the real impact of section 18 has to be seen with a very critical perspective, and we find that the entire process of prevention of market from iniquity and at the same time giving a kind of a level playing field to the free and fair market and maintenance of reasonable trade practices happens to be one of the great takeaways from these two laws, which has been endorsed and which has emerged as the major outcomes of the comparative law. Uh, Besides that fact that it has been noticed that the several courts of very special nature dealing with matters of competition law at all the states, whether it is developing country or developed countries or underdeveloped countries, together are in line with the basic precept and the practice of extraterritorial application and extraterritorial jurisdiction in matters of competition law to take care of their domestic market and free flow of the goods and services at the global level. But there are also some countries, along with the United States and European Union and India, that still need some kind of a modification to come very closer or happens to be in complete compliance of the United Nations Conference on Trade and Development Model Law on Competition 2010, and as well as United Nations Conference on Trade and Development on multilaterally agreed equitable principles of 1980. It means they have still a long way to go to refurbish their national and the regional competition law to come in consonance with and to synchronize with these laws, it especially in matters of fast track adjudication and matters relating to the competition dispute. The major problem in this regard, what we feel and face, and it is being faced by the many countries and many commentators on the competition law, have dwelled this question very precisely and very pertinently, that the proactive role of the government in ensuring good diplomatic relation with the countries also serves in a very auxiliary manner to see that the competition disputes or alternative dispute redressal mechanism and the fast track adjudication of the competition disputes in matters of enforcement of extraterritorial application of competition law or in matters of providing remedial action or competition remedies in matters of extraterritorial application of the competition law is to be seen with great hope. And we have to wait and watch that how the practices and the convention of the different countries of the world happens to be magnated and coming closer to the term of these two internationals of law by ensuring an effective policy along with the ratifications of various bilateral and multilateral instruments that governs the competition law in the country, and that has to be is still seen with great hope, and it is generally considered that these countries are going to have at least some kind of a meticulous exercise to see that what are their peculiar requirement at their territorial jurisdictions, and they have to study carefully that how these problems are to be tapped and to be harnessed and resolved and adjudicated in a timely and effective manner. Then, dear learner, while discussing the comparative law perspective on the embarrassment of extraterritorial application of competition law in developing country, we will try to see besides that what are the inherent nature of the comparative law and what perspective we are going to draw out of the entire discussion, and what happens to be the trends of the comparative law in fostering the embracement of the extraterritorial application of competition law in developed and developing country. We see that how the United Nations uh, Conference on Trade and Development's Model Law 2004 2010 and United Nations sets of multilaterally agreed equitable principles of 1980 has all potential to emerge as in such a way that it can really serve and really motivate all the states and all the member countries to come closer and to see that their law should be in order and put their house in order, and keep their cupboard very clean, and then only then we can expect an effective enforcement and effective competition remedies in matters of extraterritorial application of competition law. Then, what we have gathered out of this discussion, dear learner, is the basic fact that the transnational cases investigated by the developing countries' competition agencies have encountered a variety of challenges, and those challenges which pertains to the procedural rule, which pertains to the evidence collections, which pertains to the non-compliance, which pertains to the political pressures, which pertains to the regional trade blocks interferences, and these are considered to be one of the major stumbling block and hindrances to not only the enforcement but embarrassment as well as the remedial action of the competition law. And it also try to see that how the other problems comes when it comes to the adjudication of the competition dispute or resolving the competition dispute in a very amicable manner, and in a win-win situation. Then what we find that the investigation of the international cartel or the anti-competitive practices are mainly and primarily attributed to the delays in notification and difficulties in serving legal notices. And then the transnational enforcement requires a lot of collaborative effort and platforms besides sharing good practices and building trust among the agencies. So, what, dear learner, we learned out of this lecture on the comparative law perspective is to see that whatever the corpus of the competition law which has been handed down to us by the state practices. And we have already noted down that point, that the 40 countries of the world which has been surveyed by the United Nations organization, and try to see the nature and trend of the extraterritorial application of competition law, have rightly concluded that only 34 countries have responded, and there are certain countries which have extraterritorial application of competition law on the statute book, and there are countries which are yet to insert any kind of any specific provisions of extraterritorial application to their domestic competition law. And then we find that even if those countries which have the advantage of the competition law, as well as a very specific provisions of extraterritorial application of competition law, the problems of those countries which have this provision and the problems of those countries which are yet to have those provisions shares a common trajectory and a common problematic, and that problematic is that they have still not in a position to see that how the substantive part of the competition law in matters of embarrassment and in matters of enforcement or in matters of the remedial action should have a kind of a refinement and reform in the procedural law, because this is precisely at most required, because ultimately those disputes are to be resolved, and the adjudication of dispute here is not a kind of a dispute which can suffer from the delay and the latches, as generally happens to the routine legal battles and legal cases. These issues are having so important that it has to have a very effective, not only effective, but expeditious disposal of those dispute. And that adjudication, when we talk of and we see that how that dispute are to be fast tracked, that how that dispute are to be made time bound, and how the pronouncement are to be delivered in a time frame, then the issues which actually crop at the investigation level, the issues which crop at the evidentiary level, the issues which crop at the notification level, the issues which are being confronted at the service level, and then those issues taken in a very right perspective, see that national law, be that national law or be that the United Nations Conference model law on competition, or for that matter, the United Nations Conference law on sets of multilaterally agreed equitable principles of 1980, we seem sometimes very helpless, and then the long arms of the law and the courts in those matter are being shrugged off in that manner, and even then, despite their best intention to see that cases to be wound up in a timely frame, but generally it happens that the transnational investigations takes a lot of time, and the countries, there are countries which, despite having their laws or not having that the competition law and transnational application of competition law provision in a very specific manner, seems very incapacitated, and that sense of legal incapacity is is one of the major problem. And I think, and I just give a kind of a questionnaire to dear learner and viewer as to how we can see we will come out of the impasse which has been created by the diversified approaches of the extraterritorial application of competition law at different national jurisdictions, and how the sets of international soft competition law happens to exist. But can there be a kind of a space which can be created for comparative law perspective, and the comparative law perspective, that that not only consolidate all these laws, but they also try to simplify that law, and the consolidation and the simplification and codification of that laws, of the competition law, extraterritorial competition law, seems to be of utmost necessity, and that has to be done with the right earnest to see that the fruits of the competition law and on international law, or whether the national law, the comparative law, can be a kind of an alternative and a concurrent kind of the legal backup and sanctions to see that the extraterritorial application of the competition law goes very well. And here I pause and I just offer a kind of a questionnaire to you, and you ponder upon those issues and try to clearly spell out as to what are the broad goals of the comparative law on the embarrassment of the extraterritorial application of competition law. With this, I conclude this lecture on uh, comparative law perspective on the embarrassment of extraterritorial application of competition law. Thank you very much. Happy learning.